Good morning, everyone. Can you hear me? Good morning. Happy Cybersecurity Awareness Month. My name is Elizabeth Rogers, and it is such a privilege to be here for the 6th Annual Houston Cybersecurity Summit. There's so many people that have been involved in this program for years, and it's only gotten bigger and better. And the way I became involved is that I was the first chief privacy officer in the state government for Texas back in 2011. And from there, when the comptroller that I reported to did not run for re-election, I went back into the law firm world, where I've been practicing at the law firm of Michael Best and Friedrich as a data privacy and cybersecurity attorney since there were no laws. And the earth was not quite cold, but only recently have we all been aware in the last 5 or so years since GDPR and other laws have surfaced that there are actual legal standards that now exist. And so before we get into that topic, what I'd like to just echo with Kimberly's presentation. Thank you so much for that presentation. It was such a great choice to set the table. Part of my background also includes that out of 31 years, last year I was the very first woman chair of the Computer and Technology Law section for the State Bar of Texas, and I'm very proud of that. My grandmother, who only spoke Spanish and walked across the border into El Paso when she was 14, would be proud of that as well, even though I don't know how to milk a cow or wring a chicken's neck like she taught all of my aunts and uncles and dad to do. But I'm pretty sure she could use an iPhone. And we're going to get started. And I would like to introduce my co-presenter, Madhu Maganti. And Madhu, please feel free to introduce yourself.
Thank you, Elizabeth. Good morning, everybody. It's a pleasure to be out here. Good to see people coming out early to, listen to cybersecurity topics. Not too often that you see too many people show up this early, so thank you. And I think we're just getting the slides set up and we'll be ready to go.
Okay, fantastic. So while they're doing that, it's not the first time that a program about technology has some kind of AV issues. Let's talk about some jokes, okay? So I don't have any raffle giveaways for who gets a correct answer, but hey, Madhu, did you hear about the threat actor who got away?
He ran somewhere?
He did. In fact, we
didn't practice this, I promise. I was put on the spot.
We think he might have gone fishing. So
that too. Good one.
Okay, so I kind of know. Okay, that's okay. We can wing this. So what we're going to do is, because Madhu has a subject matter expertise in cybersecurity, he's also a CPA. There's lots of things. He's too modest to discuss about what he does. We're going to have a conversation, and we invite you to participate because most of these standards are brand new. These laws are brand new. The cool thing, though, is the standard really isn't. The standard that most states have adopted for whether or not your cybersecurity program will pass the regulators' test is whether or not you have a reasonable security program. So you might think, what does a lawyer know about reasonable security, right? And so that's where the education part comes in, that part of the content. But Madhu and I are gonna, like I said, trade, and Madhu is gonna talk from the subject matter expert role from the technical standpoint, and how do you operationalize that? Now, I know we have your 100% attention, but we only have you for 35 minutes. And so given that we have a little bit of a delay on the slide, we're not going to stop the show. We're going to keep going and start out with the fact that there are federal, state, and regulatory standards that have been developing while all of us have been looking for the right people to hire to help us comply with those. So in the federal level, I will tell you that it's very unlikely that the American Data Privacy Protection Act will pass this 117th Congress. Yay! Woohoo! Big round of applause. Thank you, Reva. Thank you. So first, we already told our joke, but we do know this happens to everybody, right? Like, we're trying so hard to do our part. Now we got to figure out, how do we get reasonable? And here's where we are going to go forward. We're going to talk about some very good resources from a practical standpoint. How do you get to know about this? And then Madhu's going to tell you how to do it. And then we're going to go into some key developments involving legal requirements, states who are setting the pace. And then finally, some case studies, just from a very high level. So before we start, this is kind of an area where I wanted to point out that when the California Consumer Privacy Act was passed in 2018, it was the very first time that cybersecurity and privacy intersected. There have been, other states building on that law, but in June of last year, following the Colonial Pipeline ransomware attack, it was the second time a sitting president of the United States of America intervened. And this time, he wrote a memo. The first time was in 2011. How many remember Obama's executive order? Okay, that was when all of us sort of had the 5 questions you ask when you have a cybersecurity attack. Well, a little over a year ago, President Biden decided to issue a memo to the C-suite of private and public sector organizations saying this is some ways you can prevent a ransomware attack. And these were all rooted in the principle of reasonable security. Now, from a legal standpoint, if I had that memo today and I were on the plaintiff's side, which I'm not, I help companies, but a plaintiff's lawyer would have that memo and they would turn to Madhu and they would say, Mr. Maganti, did you happen to look at President Biden's memo of June in 2021?
Yeah, I did.
Okay. Did you take the steps that President Biden recommended in that memo for reasonable security?
I did. I quite understood that, but I'm not sure if I went the entire extent. I kind of worked on those points that actually made sense from my industry, my organization, and went ahead going about doing that.
Ladies and gentlemen of the jury, I'd like you to instruct a verdict in favor of my clients who got damaged by a breach. Mr. Maganti's not even sure he did anything that was reasonable. Do you follow where I'm going with this? Because it doesn't matter if any of the laws we talk about this morning impact your company. What matters is there is a standard of negligence that is underlying every single law now, and even if the law didn't apply, then it means that a plaintiff's lawyer can file a lawsuit for a Deceptive Trade Practice Act or for negligence. Oh, great. I'm sorry, thank you. So that's where we're going to start focusing, and these are the things that the memo said needed to be done. And so, Madhu, why don't you take it from
if you want to go back the previous slide, right? So multi-factor authentication, I mean, it is what you know, like password, what you have in terms of your smartphone and any PIN, and then what you are, biometrics, right? So if somebody gets a hold of your credentials, you're toast. I mean, if that is all that you're doing. Nowadays, you've got all of these different opportunities with multi-factor authentication, where it's inbuilt either into Office 365, Gmail, you name it, you've got those options, and it's not something that you spend tremendous amount of money to put into place either. So go ahead and get that put into place. If we were to go into endpoint detection and response, obviously that's something that has gathered steam in the recent past. You want to make sure that not only are your threats being analyzed, you're able to respond to them. And encryption, I mean, it's something that goes without saying, but then as we'll touch upon this in the future slides with Zoom, those are areas that do cause a lot of pain, especially if you don't have encryption and somebody's lost their laptop, the access point is pretty straightforward. If people do save things, on their local drive, any hacker would be able to kind of work through it and gain access to it. So encryption is a big, challenge, but it is something that's easy to put in place given all the technologies that are available in this day and age. From a skilled, empowered security team, this is something where we do run into cases where, there are companies of different sizes. It may not make sense for everybody to have, a skilled team. So those are opportunities where you can have folks who are outsourced. Make sure that you're working with the right partners there. Most times in this area, when I go and talk to, small, medium-sized companies, they do feel like their IT managed service provider is the person handling their security, which could be fair in some cases, but most times is not, because what the IT managed service provider is doing is basically ensuring that the systems are available and so on. They are leaning on management to provide them with the policies and procedures that then they can start installing and putting into place, so overall the security posture is high. So don't place all your confidence in your IT managed service provider when it comes to security. Make sure that you have a say in those policies. And backing up your data, that goes without saying. You want to make sure you back it up, but make sure you test it. Going back to our first routine, right, with the whole joke, there was a recent cartoon that just came out where somebody ran up to their CISO and said, hey, we've gotten breached, we've been hit by ransomware. And the CISO's like, hey, did we get all our backups done? They're like, yeah, everything's done. And then it's like, where's the backup? He's like, yeah, on that server that got breached. So, it tells you everything. You want to put common sense into effect. You want to make sure you test your backups, the entire procedure of testing your backups. It's not just ensuring that the backups are happening. Make sure you know that you can retrieve them when you really need them.
Excellent point. And I think one of the takeaways on this slide too, as Madhu pointed out, is all organizations need to get here, and it might be a different way for each organization. Some organizations may have the resources to have their own team on their payroll, but others, as Madhu pointed out, you may have to supplement by getting vendors. But just for a show of hands, how many of you are aware of whether your organization uses MFA? Okay, that's fantastic. About 5 years ago, that probably wouldn't be that many people. Back then, 5 years ago, it probably wouldn't be a minimum requirement. But today, chances are that if an organization doesn't have it and a regulator finds that out, then it will automatically be declared as an unreasonable security program because it's become so easy. So those are the ways to look at what is reasonable. It's just a snapshot because some organizations don't need, the full suite, the comprehensive suite of solutions. So that's to get us started.
And Elizabeth, one quick point there. So it does help these days with cyber insurance that they do ask for certain things to be in there. Multi-factor authentication is something they absolutely need before they would even put into place. So, we do seek the help of not only regulations, but some of these outside parties that support your entire cybersecurity environment to kind of enforce certain things to then put these best practices in play.
That's a great segue to the next slide. You want to take it from there?
Sure. So, what does it mean to follow reasonable security standards? So when we go out there as a third-party independent, organization that conducts assessments and so on, we do not go out there looking only primarily at the technology aspect. We look at people, process, and technology. And I believe the risk is in that order, because in any room or in any organization, people are the weakest link. Then you've got these processes, then you've got technology. You could get $1 million of technology, but if you've got people who aren't aware within your organization, or if you've got processes that can circumvent your technology, I mean, you're already in the red. So we try to promote that proactive culture where everybody is aware, create that awareness, create those policies, procedures, walk through your entire workforce, ensure that they are acting as your guardians. Because at the end of the day, I mean, if you've got an organization with, let's say, 10 people or 500 or 5,000, you want them to be the guardians of that fortress that you've created for yourself. If you have somebody who, or an organization where they don't know what they need to be doing, they'd be the first ones to allow folks to tailgate. I say this in pretty much every talk, that when we go out and do certain assessments, all it takes is for us to wear a suit and then look like we're really angry, carry some pieces of paper. We'd get through security, we'd get through receptionists, no problem asked, because they think we're in a position of power.
Well, that's because that's what Jerry Seinfeld said to do. He said just to walk around looking mad, and it really makes you look busy and important. So, but the legal aspect of slide 7 is to do all of these things, but now with the advent of GDPR, it sort of set the table for what needs to be done to save you when you're being audited. Yeah. So showing accountability is a huge part of the legal defense posture and the insurance qualification posture. Having a record of what decisions you made, what steps you chose to take, and if you chose not, for example, to have a particular product or a person, why did you make that decision? And maintain those notes, keep them up to date. So that's one way to establish your reasonable security, is that you took it seriously, you had conversations. And so this becomes relevant as well under the Section 5 of the FTC Act. And the reason that is so important for us is that for companies that are regulated by the FTC, which excludes most of the financial institutions and healthcare organizations, Section 5 is a standard of deceptive and unfair trade practices. And so on the federal level, that's how the regulators look at just simple things like your privacy policy, but other things that are more important, such as, for example, we look at the apps and the privacy policies and data collection for a variety of different industries, but just as one example, a fetal heartbeat monitor that is where you can send the sound of the baby's heartbeat to the grandmom or the uncle or aunt or whatever, was an innocent app that was developed, but the developers did not translate to the marketing team what data was being collected, and therefore the privacy policy did not disclose to the parents that some of this data that was being collected was being used for other purposes that were good. But the point is that having all of the people talk together in the same room is essential to show that reasonable steps were taken to protect data. So that particular app got scrutinized by the FTC is a point of this case study. And it is the same type of standard that the attorneys general throughout the US are going to use, whether an act was deceptive or unfair. So that's pretty much the federal landscape. I want to move quickly into the state, just because that's kind of around the corner for all of us. So Madhu, why don't you just talk about what the state of the state's activity has been so far?
Yeah, so, we've seen, obviously, CCPA and CPRA coming into place, CPRA in 2023, I believe, and we've got Utah, Colorado, Virginia, Connecticut. So all of these are pretty much mirroring what GDPR has put into place, but you also have areas where they've gone a little above and beyond that. And then in committee, you've got all of these other states, and I think, Elizabeth, you can kind of touch upon some of these aspects that'll, throw into light some of the security reliance from a privacy perspective?
Yes, so surprisingly, a lot of people are unaware that there were and are reasonable security requirements before these laws that were already passed in 15 states. These particular states where the laws have been passed to protect consumer data privacy specifically, they're now, if they're not in place, there will be citations for violations of the laws. The only states that have issued regulations, just so you know, in California, the CCPA regulations were published a year ago. We're still waiting on the CPRA regulations, which were supposed to be published in July. And on Monday, the Attorney General of Colorado published the Colorado regulations. Without those, we are refraining from giving specific advice on exactly what those states require as far as what the privacy policy should say, other than what's in the black letter law. But just be aware that when those states do come out with their regulations, they may differ in letter and in, not spirit, but in letter from the actual law itself. The bottom line is that this is the framework that if you develop that type of approach and a comprehensive approach, once all of these state laws come out one at a time, then you are going to be compliant. It's the same as it was when GDPR came out. And also, frankly, if your systems, if your networks are HIPAA compliant, chances are they are compliant with all the rest of the very strict reasonable security requirements. So
I had a question for you. So in terms of all of these different state laws, you've got GDPR. So how do you go about working with your clients when they have to hit different state privacy regulations, but they've also got some overarching GDPR sort of privacy laws that they need to stay compliant with as well?
Sure. So very fair question. So if the company already became GDPR compliant by May 25th of 2018, they're ahead of the game. The rest is to try to look at what is required across the board. So we have a chart that we work from right now, helping clients to comply by the time that Virginia and the CPRA take effect in January of this year, to harmonize consent requirements, disclosure requirements, data subject rights, ad tech, regulation of advertising technology across the board, so that companies are prepared, and we don't have 15 different state privacy policies, right? Remember back in 2020 or the end of 2019, first you had this huge wave of new privacy policies after GDPR. Then right before New Year's Eve on 2020, you got all of these California privacy policies. We're advising of having all one master policy, because consumers are not gonna, it's gonna be, I think, in my opinion, a backfire if we make our customers, our website visitors, look at 15 different policies to make sure, that they know what data is being collected. So we're harmonizing.
Okay.
That's why we.
No, it would be a consultant's dream if they were to kind of work through every 15 states, and your security budgets only go so far. So another point I just wanted to make from a compliance standpoint is that people assume that complying with certain laws means your security posture is high as well. So you want to make sure that compliance means minimum requirements, but for your industry, for your size of company, you probably want to take additional steps and work with somebody. You probably have, established CISOs who are in the know in terms of where you need to up your game with certain areas, but make sure that you just don't rely on compliance as being one of those items that, you're done, and that means your security is, above par. It's probably on par. You want to take it slightly a step higher to stay current with your threat landscape, which is changing almost on a daily basis these days.
And that's a very good point to make because, as you point out, being compliant does not necessarily mean that the security is there. And one of the biggest case studies we probably won't have a whole lot of time to talk about today, but I invite you to review it at your leisure, is the settlement that the FTC made with Equifax following their data breach. And as you all know, they collect over 100 million social security numbers were compromised in a data breach that was a textbook example of a company that it means well, and this is not intended to insult Equifax, but the problem is that everything was available to help them prevent this, but it takes a lot of coordination. It takes all the silos being broken down. There was a CERT alert, the CERT alert for those of you who are in that industry that went out saying a JavaScript patch needed to be updated. And so Equifax did what many companies did. They searched all the systems that they had on their inventory, that thought were on the inventory, but they were unaware that there was a legacy system that was not connected. It wasn't a part of the inventory. So that was the second wave of numbers that were compromised. On top of that, after the patch was put into place, the security team failed to go behind that patching to test it, to see if it worked. And had they done that, they would have found out it didn't work. So it takes a lot of people together working, and not just when there's a massive data breach, but on the prevention side as well. And so that's what these laws are intended to put into place now on a mandatory basis, going behind the scenes, making sure you have these written information security programs, you're doing the risk assessment. So all of the new state consumer data privacy laws that take effect next year are going to require annual testing. So I'd like to just move a little bit faster and get to just here where you will see some highlights. It means that states have enacted already the reasonable security requirement and what happens if you don't reach that. And so, Madhu, why don't you talk a little bit about the key developments that have arisen since 2020 and COVID?
Yeah, so obviously everyone's gone remote. I was just thinking while Elizabeth was talking about about all of those prior points that, with Equifax, Uber is back in the news, right? If you've seen, the Uber CISO was again found guilty for not disclosing a breach that happened while the FTC was going after them. And no 5-star rating there, right? So with all of these, new developments that have come into play, everybody's going after folks for obvious reasons for not complying, because they do feel like all the consumers need to be protected. The power is going back into the hands of the people. All of our data, data is king, right? Anything that people are going after is the data, be it a small company, be it a large company. Now, you do have cases where with all of these different NIST standards that come out, there are changes every now and then to keep up with what the threat landscape is like currently. You want to make sure that you're staying on top of it. With everything that is going on with IoT, you've got these new standards that are coming into play. You want to make sure that you're covering it. Your fridge now listens to everything you say. There are problems, right? So Alexa has been shut down in my house because it made a purchase when I was in a movie theater, and it was just my dog at home. My dog can't talk, I promise you. And somebody bought a My Little Pony Express, which was a $10 purchase. I don't have kids, so I was scared. Alexa's out. We don't even use it as a speaker now. So be a little careful about IoT, but use compliance and standards, especially if you're using it within your organizations, because everybody has got IoT within their organizations, whether you know it or not.
Excellent. So some of these we've already spoken about, so I'm not, I promise you, not shortchanging. I'm just trying to get through a couple of these slides while we have time. And only just the takeaway is to realize that these requirements of reasonable security measures are going to continue. The good news is there's not prescriptive requirements, right? I mean, so many of us wish we knew exactly what does reasonable mean. If we do steps 1 through 5, can't we get a break after a data breach? Can't we get like a safe harbor cap on liability? The CCPA has started that. For example, if the company can establish that their security program was reasonable at the time of a hack, which happens all the time. You know, a company becomes an innocent victim, just like the consumers. That is a defense. So finally, we're getting a little bit of a break on the policy side, but I think it's helpful for us to have the reasonable security framework, and I'd like to sort of throw that out there while we have you. How many of you have any opinions one way or another about what, if it's harder to follow the reasonable security, easier? What do you think back at your place?
Rogers, I believe that all these points are well taken. I am one of the cybersecurity COO. We actually can quantify the cyber risk. And these are textbook answers. I believe that many companies cannot practically do and follow these things. I believe that, and I've been in this for a long time, because we underwrite and quantify cyber risk for insurance companies so they can underwrite the policies. It's impossible for any organization to do reasonable, because in which eyes? Your customers? Have you ever seen COO or CEO who will cut $10 million check because you are doing reasonable things without quantified data? This is very impossible task, and I believe that I'm not 100% sure that intent is definitely good, but I think that there is the reasonable belief that this is done by government, because not only companies will be attacked, but then the government will come and kick you in the teeth.
Okay, so if I'm hearing you right, it's the intent behind a reasonable security standard is well placed, but we need to do a better job quantifying the performance of our systems, being able to demonstrate to insurance carriers that what we're doing is working, or if it's not working, those metrics will help us get to a better maturity level. Is that what I'm, okay.
Like, just, I don't want to steal, 25% of healthcare organization in Texas paid ransomware $6 trillion last year. That means every fourth hospital in Texas has the problem with cybersecurity.
And yeah, that's fair.
It would be helpful if the law would prescribe what exactly needs to be accomplished, because reasonable is kind of vague.
Yep, it's true. I mean, and that's an ironic category of such a high incident, because HIPAA does have more of a prescriptive, solution, like what needs to be done in the regulations. But point well taken. Madhu, do you have any?
No, I think you covered that. I mean, we've got a lot of clients where, certain things just cannot be done. And then it's how you document it, how you, even with GDPR for that matter, right? How many of you can actually say that you're completely compliant with GDPR? You want to make progress towards it, and I think there's a question for you in terms of dealing with the regulatory authorities, be it the OCR for HIPAA or anybody else. You want to show that you've taken the right steps towards meeting certain things, given your current disposition, how you're at and what you're doing and so on. So it's very hard to meet everything, but you want to at least show that you're taking positive steps as opposed to just sitting back and, saying a prayer.
I have one more question. We actually predicted Equifax 2 years ago that they will have 80% chance to be hacked, and it would cost them $100 million. We were unfortunately very correct. Here's my question. We send the companies those reports, like you are about to have a heart attack. most C-suite executives do not want to have these reports, because when the lawyers come, now they've been hacked, and they claim we did not know, we tried to be reasonable. But if you have a report which quantified this, now they are a willfully negligent, which is illegal. What do you think about the effect of these laws on fear of C-suite executives to do anything meaningful, because kind of law requires the personal liability? We have seen many CEOs drag in front of Congress and lost their benefits. What do you think?
Well, let me answer that by a lesson, and that is consistent with what we're discussing today. There is the privilege that attaches to an attorney's advice when a client is determining if they've met the reasonable security standard or if there's a lapse. And so that is a fair privilege that we promote in our legal services. But you know, what the company's obligation is to follow what law may apply. If there's not a law that applies, the FTC says security doesn't have to be perfect. Okay, so it only has to be reasonable, and you don't have to be a security subject matter expert to meet that standard. So I think it's fair to incorporate your point to say that companies need to monitor their maturity level at all times, like Madhu said. Make sure that you're monitoring it. You don't just put your security assessment results on a shelf. You're keeping up with what standards may have developed, like MFA, and you welcome, perhaps outside vendors, depending on whether they're friendly or not. Consider the resources being offered from all levels. That's definitely a huge takeaway for today.
And I've got a question for you. So you'd mentioned you'd predicted Equifax 2 years ago. So who's next? That's interesting.
Okay, so we're going to end. We're going just a little over to keep our full time, but just to go through some of the key affirmative security requirements. Madhu, this is sort of in your will space to talk about what is going on with some of the more robust attacks, like denial of service attacks and Internet of Things, supply chain attacks.
Yeah, I mean, look, no one is sitting around these days just waiting for things to happen, right? You need to go ahead as a hacker. They're getting all the latest and greatest tools. They're putting things out there, feelers. They're gathering information passively, able to get in. DDoS attacks are commonplace. Everyone's working towards, ensuring that those are taken care of. You've got, now we've got this whole digital supply chain where things are moving towards. So you want to make sure that you're taking care of those aspects. Continue to do all of your security risk questionnaires with your third-party vendors. Just show of hands, how many of you actually send them out to third parties before you bring them on board?
And so the legal team works with the subject matter experts doing the technical side to give an assessment of whether or not the steps taken would qualify either under a prescriptive law like HIPAA or nowadays under the reasonable security model. And so we rely heavily on the client internally to do their own self-assessment first. Then we get an outside assessment that's more technical in nature, more robust, but we work together to help them to determine whether or not this particular posture or maturity level would be scrutinized by a regulator, because now, unfortunately, we have a lot of data to show what do the regulators expect, and do you meet that expectation that a regulator would have. We are about to close. I know we don't want to stand between you and a break, but if anybody has any questions, please ask them now or, oh yes, please.
can I meet these requirements? I depend on my EHR vendor to help me, but I don't know how they can possibly do it. And I'll point out that St. Luke's CHI Epic just last week went down completely for some reason. I don't know what it was, but the entire electronic health record for St. Luke's was down. Nobody's talking about who did what at this point. We're just trying to get people back up so that we can see patients. This is a huge problem, as you're pointing out, at both a tiny level like me, a big medical system like St. Luke's and his millions of people. We're all in this together.
Yes. Thank you so much for coming, and thank you all for your attention. Enjoy the rest of the program.
Thank you.